Good afternoon, everybody. Happy Law Day. Thank you for coming over. Before I introduce our speaker, I'd like to invite you down to the State Law Library after the CLE. We are celebrating Law Day in a few different ways. We've got some great giveaways that you can register for. We have some constitutional trivia that is tied to the topic today, and we'll have some great cookies after lunch. So please join us afterwards for some more celebration. I'm just delighted to have our speaker with us today. Professor Levine has been a law professor since 2001 at the Mitchell-Hamlin School of Law, where she teaches constitutional law, media law, election law, and torts. After graduating with honors from Stanford Law School and clerking for the Ninth Circuit, she served as an attorney for the Southern California ACLU and other public interest-oriented law firms. Her scholarly interests focus primarily on First Amendment rights of freedom of speech and press, stemming from her pre-law school experience as a news editor and producer for CNN Headline News. She frequently serves as an expert on First Amendment and election law issues for both local and media for both local and national news media. Please help me welcome our presenter today.
All right. I'm going to be talking today about prior restraints, and particularly prior restraints on the press. I'll start with a historical overview of prior restraints, turn you to the United States Supreme Court seminal prior restraint case, Neer versus Minnesota, which I saw is highlighted in the showcase downstairs, which was decided in 1931, and then move over time to some pending cases that raise the question of whether a prior restraint should ever be issued against speech on the internet or social media on the grounds that it poses a threat to national security and safety, and if so, under what circumstances it should be issued. Okay, so when we talk about restrictions on speech, we generally talk about two categories of restrictions: subsequent punishments and prior restraints. Subsequent punishment is a penalty for speaking, whether a fine or prison time or damages in a civil case, such as a defamation case, imposed after the speech is released, after it is spoken out loud or published or broadcast or posted or tweeted or otherwise disseminated publicly. With subsequent punishment, the speech has a chance to be heard by an audience at least once. A prior restraint, on the other hand, is a bar on speech being published or released. It is the essence of pre-publication censorship. It keeps speech from ever getting out to the public. Originally, prior restraints meant licensing requirements. Printed publications and later other forms of speech, movies, for example, could not be released until the government's executive branch, through an administrative agency, gave its permission through a licensing process. Historically, prior restraints have been a problem for speakers, and particularly for the press, for centuries. When a commercially viable printing press was invented in the late 15th century, many governments tried to constrain its use. In England, for example, the government attempted to control the press in a variety of ways, including banning printers from publishing works that government officials had not licensed. The government could censor passages it deemed objectionable, or simply deny a license to print altogether. And Parliament enacted a series of acts making it a crime to print a work without a license. John Milton wrote Areopagitica, his powerful essay opposing licensing and justifying freedom of speech in response to these laws in 1644. Milton noted that ancient Greeks and Romans had never required that speech be licensed, that is, that it be government approved. So writings that were considered blasphemous or libelous in ancient Greek and Rome were burnt, and their authors were punished, but it was after production, after the works had been publicly released, that these texts were rejected rather than prior to their release. And Milton argued that a work should be examined, refuted, and condemned after it was disseminated, rather than being printed before the public could review it, rather than being prohibited before the public could review it. As Milton explained, the Catholics first instituted licensing with the medieval inquisitions. Beginning in the 14th century, there were popes in Rome who became tyrannical licensors. For example, Pope Martin V became the first to prohibit the reading of heretical books. In the 16th century, the Council of Trent and the Spanish Inquisition prohibited texts that were not even necessarily heretical, but only unfavorable to the friars. Milton argued passionately and persuasively that being learned means reading books of all sorts, even bad or heretical books, because we learn from their wrongs and discover what is true by considering and reevaluating what is not true. So Milton's point was that every person is endowed with the reason, free will, and conscience to judge ideas for themselves, so that the ideas in a text should be rejected by the reader's own choice and not by that of a licensing authority. Milton's work was so effective that by the time England's last licensing legislation expired in 1694, it was neither renewed nor replaced. And in Blackstone's Commentaries on the Laws of England, published in the mid-18th century, Blackstone cemented the Anglo-American understanding that while speech may, and in many cases should, be punished after it is published, prior restraints are antithetical to a free press, which is critical to a free society. Blackstone famously wrote, "The liberty of the press is indeed essential to the nature of a free state, but this consists in laying no previous restraints upon publications and not in freedom from censure for criminal matter when published. Every free man has an undoubted right to lay what sentiments he pleases before the public. To forbid this is to destroy the freedom of the press. But if what he publishes is improper, mischievous, or illegal, he must take the consequence of his own temerity." So even before the US adopted the First Amendment in 1791, both the English and Americans understood that licensing requirements, prior restraints, were inconsistent with freedom of expression, though subsequent punishment of speech could be permissible. And while no one has ever seriously doubted that the First Amendment was intended at least to forbid prior restraints, at early common law, the definition of prior restraint covered only administrative agencies granting or denying permission to publish. It did not extend to court-ordered injunctions, judicial prohibitions against publication. Thus, when the United States Supreme Court decided Neer versus Minnesota in 1931, the notion that a judicially issued injunction against future publication violated the First Amendment's guarantees of free speech and a free press was not in any way a universally accepted truth. At issue in the case was the constitutionality of a Minnesota law known as the Minnesota Gag Law. The Gag Law was a public nuisance statute aimed at shutting down muckraking scandal sheets, known as yellow journalism. And several state legislatures who had been targets of defamatory attacks by such scandal sheets pushed for the law as a way to shut down yellow journalism in Minnesota once and for all. The Gag Law provided that any person who shall be engaged in the business of regularly or customarily producing, publishing, circulating, having in possession, giving away or selling a malicious, scandalous, and defamatory newspaper is guilty of a nuisance, and all persons guilty of such nuisance may be enjoined from further publication. Someone charged under the Gag Law could avoid the injunction only by proving, as an affirmative defense, that what they had published was true and that they had published with good motives and for justifiable ends. The newspaper at issue in Neer versus Minnesota, called the Saturday Press, you can see a copy here of the front page of the paper, issued at a time when the police chief was engaged in this action to try to shut down the press. Was a tabloid-style, sensational weekly filled with lurid descriptions of sex. It included terrible slurs against and baiting of minority groups. It was virulently racist and anti-Semitic. But it was the Saturday Press's frequent attacks on public officials, including the Minneapolis mayor, the chief of police, and the county attorney, that really got their attention and their vote. The Saturday Press repeatedly charged that these officials were aligned with gangsters and were not doing their jobs to prevent and punish gangster activities of gambling, bootlegging, and racketeering. Just as a side note, can you imagine today a newspaper being enjoined from saying that law enforcement officials were corrupt or were not doing their jobs? What would our society be like if the press could not freely criticize the police and elected officials? The county attorney, Floyd Olson, filed a complaint in Hennepin County Court charging that the Saturday Press had defamed him, the police chief, the mayor, 2 other newspapers, the Minneapolis Tribune and Minneapolis Journal, as well as the entire Jewish community of Minneapolis. Olson requested an injunction pursuant to the Minnesota gag law against any further publication of the newspaper. Jane Neer, one of the publishers of the Saturday Press, responded by claiming that the gag law violated the United States and Minnesota constitutions. Hennepin County Court Judge Matthias Baldwin issued the requested injunction, barring not only the paper's then publishers, but also anyone else ever from producing, publishing, editing, circulating, possessing, selling, or giving away the Saturday Press, whether current or future editions, as well as any other publication by any other name that contained any matter of the kind alleged in the complaint. It was the essence of an overbroad order. Nonetheless, the Minnesota Supreme Court upheld the injunction and the gag law as valid exercises of the state's police power. Minnesota's justices held that the law and injunction were reasonable and that there is a legal obligation on the part of all who write and publish to do so in such a manner as not to offend against public decency, public morals, and public laws. When Jane Neer petitioned the U.S. Supreme Court for cert and the court granted cert in 1930, Neer versus Minnesota became the first prior restraint case to reach the Supreme Court. It was a close decision, 5-4, authored by then Chief Justice Hughes, and in it, the U.S. Supreme Court held for the first time that the First Amendment guaranteed the press freedom from prior restraints, including judicial injunctions. Chief Justice Hughes wrote, "The fact that the liberty of the press may be abused by miscreant purveyors of scandal does not make any the less necessary the immunity of the press from previous restraint, prior restraint, in dealing with official misconduct. Subsequent punishment for such abuses as may exist is the appropriate remedy, consistent with constitutional privilege." The defense allowed under the gag law proof that the information published was true and with good motives and for justifiable ends could not rescue it from unconstitutionality. Otherwise, Chief Justice Hughes said, it would be equally permissible for the legislature to provide that at any time, the publisher of any newspaper could be brought before a court or even an administrative officer and required to produce proof of the truth of his publication or of what he intended to publish and his motives, or stand enjoined. If this can be done, Chief Justice Hughes said, the legislature may provide machinery for determining in the complete exercise of its discretion what are justifiable ends and restrain publication accordingly. And it would be but a step to a complete system of censorship. Quoting James Madison, Chief Justice Hughes said that when it came to the press, it is better to leave a few noxious branches to their luxuriant growth than, by pruning them away, to injure the vigor of those yielding the proper fruits. This is the corollary in First Amendment jurisprudence of the maxim in criminal law that it is better to let 100 guilty people go free than to imprison one innocent person. The notion is that it is better to keep the government's hands off the press altogether, even when the press is publishing despicable or fake news, so as not to restrict or chill the speech of the good press. In the wake of Neer versus Minnesota, the Supreme Court and most lower courts have considered it antithetical to the First Amendment to bar speech, to censor it. They have thus treated prior restraints, including injunctions against publication, as presumptively unconstitutional in almost all circumstances. Again, in some cases, the speech issue could constitutionally be punished after it was published with prison fines or prison times or fines or damages, but not restricted before. Since Near, the court has said that it violates the First Amendment to bar speech in virtually every circumstance, even if it could constitutionally be punished after it was published. And again, that's because post-publication punishment, subsequent punishment, with that kind of punishment, the speech at issue has a chance to enter the marketplace of ideas at least once. Even if particular speech can be punished after it's disseminated, barring it before it's released into the marketplace means that the public does not get to hear it. And it may be that once the public hears the speech, we may, as a society, decide that punishment is not appropriate. Moreover, an injunction against publication means there's a loss of immediacy and possibly of value, even if the injunction is later found unconstitutional. That is particularly a particularly pernicious problem for the news media, for whom time is often of the essence. Nonetheless, as Chief Justice Hughes explained in Near, there are, at least theoretically, exceptional instances in which prior restraints may be permissible. Some of those include injunctions against material that is properly deemed obscene, or injunctions to protect trade secrets and copyrights, for example. Another of those special and limited instances in which a prior restraint may be constitutional has come to be known as the national security exception. As Chief Justice Hughes put it in Near, when a nation is at war, many things that might be said in time of peace are such a hindrance to its war effort that their utterance will not be endured as long as men fight, and no court could regard them as protected by any constitutional right. No one would question but that a government might prevent the publication of the sailing dates of transports or the number and location of troops. The first real test of that national security exception came in New York Times versus United States, the 1971 US Supreme Court case better known as the Pentagon Papers case. The case arose when the war in Vietnam and the controversy over it in the United States were at their peak. The Secretary of Defense, Robert McNamara, had commissioned a top secret study of the history of the US government's involvement in Vietnam. The classified and huge report, it was 47 volumes, was dubbed the Pentagon Papers. It revealed that the federal government had long known that the Vietnam War would cost many more lives than the public was told, that US Marines had engaged in airstrikes, raids, and other offensive actions in Southeast Asia long before the American public was informed about them, and that the war was being escalated even as the president was saying that it was close to ending. Daniel Ellsberg, a military analyst, believed that Americans needed to know what was in the report. He secretly photocopied the Pentagon Papers, 47 volumes worth, and gave copies to the New York Times, which began printing excerpts from the documents on June 13, 1971. The Justice Department immediately moved to enjoin the Times from publishing any more of the report. The Justice Department argued that publishing the material would threaten national security. And though a district court judge before whom the case was pending in New York denied the injunction, publication was restrained pending appeal. And then on appeal to the Second Circuit, that court granted the requested injunction. It was the first time in American history that the government had successfully obtained a prior restraint on national security grounds. Meantime, though, Ellsberg released the Pentagon Papers to the Washington Post, which then began publishing material from the report. And although the Justice Department again immediately moved to enjoin the Post, a district court in Washington, D.C., where the Post was published, refused to issue a preliminary injunction, and the Court of Appeals for the D.C. Circuit affirmed. Less than 2 weeks after the initial publication, the U.S. Supreme Court agreed to hear both cases. To decide whether the release of the study posed the kind of dire threat to national security that could justify a prior restraint. The court issued stays to prevent publication in both cases on June 25th, heard oral argument on June 26th, and announced its decision on June 30th, which, as I'm sure you know, is an incredibly quick turnaround time for the court. In a brief per curiam opinion that cited Neer versus Minnesota, the court said simply that a prior restraint of publication comes to the court bearing a heavy burden against its constitutional validity, that the government consequently bears a heavy burden of showing justification for the imposition of a prior restraint, and that in neither case before the court had the government met that heavy burden. Every justice on the court issued an opinion concurring or dissenting. 3 justices, Black, Douglas, and Brennan, decided on the merits that the requested injunctions were patently unconstitutional prior restraints under the First Amendment. Justice Black, a First Amendment absolutist, said that publication of news may never be enjoined without violating the Constitution. In his opinion, the framers had determined to protect the press precisely so that it could bear the secrets of government and inform the people. Far from deserving condemnation for their courageous reporting, he said, the New York Times and the Washington Post should be commended for serving the purpose that the founding fathers saw so clearly. In revealing the workings of government that led to the Vietnam War, the newspapers nobly did precisely that which the founders hoped and trusted they would do. Justice Douglas agreed. Justice Brennan was more restrained. He acknowledged Neer's recognition that in wartime, no one would question but that a government might prevent the publication of the sailing dates of transports or the number and location of troops. He speculated that the power of nuclear weapons, for example, could be so great that whether at a time of war or a time of peace, the Constitution would permit the suppression of information that would set in motion a nuclear holocaust. However, Justice Brennan continued, the Justice Department had not proved or even alleged that publication of the Pentagon Papers would cause anything remotely akin to such a cataclysmic event. To justify a prior restraint on the press, the government would have to prove that publication would inevitably, directly, and immediately cause the occurrence of an event kindred to imperiling the safety of a transport already at sea. Justices Marshall, White, and Stewart concurred in the judgment, finding that the injunction was unconstitutional, but on separation of powers grounds. Congress had not passed any law that would authorize the executive branch to request an injunction of this type from the courts, so the court had no legal authority to issue one, especially where the executive branch had offered no proof that publication would surely result in direct, immediate, and irreparable damage to our nation or its people. These 3 concurrers believed that publication of some parts of the Pentagon Papers would cause substantial damage to public interests, but not the kind of catastrophic damage that might someday justify the issuance of a prior restraint of the type the government sought. The 3 dissenters, Chief Justice Berger with Justices Blackmun and Harlan, thought that a prior restraint either was or could be justified in the cases at hand. But they complained that the decision-making process had been too fast and frenzied to allow for the development of the kind of full factual record necessary, the kind of complete record that would permit the court to make a reasoned decision as to whether such a prior restraint was appropriate. So while a majority of the Pentagon Papers Court justices found that the prior restraints requested in the case were unconstitutional, a different majority left open the possibility, raised in Neer versus Minnesota, that a prior restraint on publication of news could be justified by a sufficient threat to our national security or safety. As we now know, the publication of the Pentagon Papers did not, in fact, offer any tactical advantage to our North Vietnamese enemies, though it certainly helped cement the American public's mounting opposition to the war. The fact that the release of the report did not result in any cataclysm is one of the reasons, I think, that there have been few cases since the Pentagon Papers case and none before the US Supreme Court in which the courts have upheld a prior restraint on the press in the interest of national security. One of those anomalous cases is the United States versus the Progressive. A 1979 Cold War era case heard by the federal trial court in the Western District of Wisconsin, but not by any higher court. In the Progressive case, the United States government sought an injunction under the Federal Atomic Energy Act that would prohibit the Progressive magazine from publishing an article entitled "The H-Bomb Secret: How We Got It, Why We're Telling It." The article was about the hydrogen bomb and how to build one. Much of the information in the magazine article was not classified. The government had not kept it secret. It was already publicly available to anyone diligent enough to seek it out. But the government contended that even if the specific information was in the public domain, publishing it all together in one readily accessible article could aid America's enemies, enabling them to put together all the pieces much more quickly and easily than they otherwise could. The magazine wanted to publish the piece for exactly that reason, to alert American citizens to what it called a false illusion of security created by the government's futile attempts at secrecy. That is, the Progressive's editors and publisher wanted to let the American people know that our enemies could, in fact, build a hydrogen bomb precisely because the how-to information was readily available. Right? This is much more persuasive, say, than simply saying this information is readily available. It's those of you who have watched television reports in which reporters managed to sneak contraband past metal detectors in airport security. That means a lot more than simply saying that you can do it, right? It resonates much more. It's much more real to people, and that's what the magazine was trying. Federal District Court Judge Robert Warren, who heard the case, acknowledged that, as he put it, you can't build a hydrogen bomb in a basement. Thermonuclear capability requires a team of accomplished, resourceful scientists and technicians and sophisticated industrial infrastructure. But he found the article could provide a ticket to bypass blind alleys, making it possible for a mid-sized nation to move faster to develop an H-bomb. So he enjoined the article. Judge Warren noted that while a mistake in ruling against the Progressive would seriously infringe cherished First Amendment rights, a mistake in ruling against the United States could pave the way for thermonuclear annihilation. Without a right to live, he suggested, a right to publish is moot. It's hard to argue with that logic. But there is a difference between would and could. The injunction would infringe First Amendment rights. The publication could imperil lives. It would be tremendously hard to be the person who decides that the intangible rights that the First Amendment protects outweigh the very concrete harms that a national security threat poses. But in the absence of proof that the threat will endanger lives, the Constitution requires, as the Neer and Pentagon Papers majorities recognized, that the court's thumb be on the side of First Amendment rights. Judge Warren, I think, got it wrong. The Progressive case was eventually dismissed after other media outlets published the same information that Judge Warren had enjoined the Progressive from publishing. And that's why the decision was never reviewed by any higher court. And as in the Pentagon Papers case, publication did not, in fact, result in any catastrophic loss of life. But while the decision reflects the Cold War era in which it was decided, it's not difficult to imagine that terrorists could use information about flaws in our national infrastructure now, about nuclear power plants, say, or about chemical or biological weapons materials, to harm or kill hundreds, thousands, or even millions of people. That kind of information is available today on the internet and accessible worldwide. So the issue then is in no way moot. Nonetheless, when Julian Assange and WikiLeaks began revealing in online posts some 250,000 secret US government documents in 2010, the federal government did not even try to enjoin their publication. The material WikiLeaks released included diplomatic cables, intelligence assessments, and confidential military information such as battlefield reports supplied by former soldier Chelsea Manning. Of course, Manning was convicted of espionage, and Assange is now charged with conspiring with Manning to hack into classified U.S. government computer files. But the federal government did not try to keep WikiLeaks from publishing the documents at issue because it knew that in all likelihood it would not be able to do so. Again, this points to the difference between subsequent punishment, a criminal conviction for publishing material that was illegally obtained, for example, and prior restraint, banning publication of the material before it is ever released. One could argue that Assange, WikiLeaks, and other internet and social media users are not members of the press, and that both Near and the Pentagon Papers case concerned the presumptive unconstitutionality of prior restraints against members of the institutional news media. But neither decision was grounded in the First Amendment's free press clause as opposed to its free speech clause. And in fact, the US Supreme Court has never embraced a view of the First Amendment's press clause that gives significant substantive rights to members of the press that are not also extended in equal measure to every other person and entity in the United States under the speech clause. States have made the distinction between the press and other speakers in the context of recognizing a reporter's privilege for members of the press. The reporter's privilege is a privilege that protects reporters from having to reveal the identity of their sources, who often request and indeed require confidentiality, anonymity, before they'll reveal information that might be of great public interest and might not otherwise be available. When a state recognizes a reporter's privilege, a person or publisher who counts as a member of the press is allowed to claim that even though she has information that a litigant in a civil case wants, or even that the prosecution or defense in a criminal case wants, and even though the person or publisher has been subpoenaed to testify and or turn over notes or recordings or photos, the reporter has a right to protect that information and its source from compelled disclosure. As you know, the beginning of this century brought a shift from what had become traditional news media, newspapers and broadcast TV, to new media, the internet and now social media such as Facebook and Twitter. For the first time in many years, newspapers and broadcast television are no longer the primary source of news for the majority of Americans, the vast majority of Americans. Online and social media sources are. At the same time, traditional reporting, which involves the gathering of news, the evaluation of the credibility of sources and stories, and the making of independent editorial decisions about what stories truly are of public interest, is shrinking. Most online and social media posts do not get reviewed by any intermediary, by a trained editor or publisher before they are published. There is no guarantee, as I'm sure you know, that anything you read on such a platform has been vetted by anyone for its accuracy. Meantime, we've seen the resurrection of the citizen journalist, a position that became feasible when the cost of publishing went down so drastically, as it's much cheaper to publish online as opposed to in a print newspaper, much less on broadcast TV or radio. And these changes have forced states to rethink what counts as the press for purposes of a reporter's privilege. Are people who reach large segments of the public through internet posts or through Twitter, Facebook, Instagram, Snapchat, or YouTube reporters? Should their motives or intent matter? Should their training matter? Should it matter whether they're affiliated with a recognized press institution, whether they're employed full-time or part-time, or whether they're paid at all? Should it matter how many people they reach? Should it matter whether anyone vets the credibility of the information they published before it's released? These are all questions that the United States Supreme Court has been reluctant to confront, indeed has been eager to avoid. And it seems doubtful that the court will reshape the doctrine that dictates that prior restraints on publication are presumptively unconstitutional to account for these new and vexing questions about who counts as a member of the press. Meantime, the government has been reluctant to request prior restraints in cases such as the WikiLeaks case, not only because of the presumptive unconstitutionality of prior restraints on publication, but I believe because of the futility of enforcing such an injunction, even were it granted. As I mentioned, in both the Pentagon Papers case and the Progressive case, other news media began publishing the material at issue even when the New York Times and the Progressive were enjoined from publishing it. Those other news media were not parties to the cases and so could not be constrained by an injunction against the parties. And with the advent of the internet and social media, it's become nearly impossible as a practical matter to keep enjoined material from leaking. First, material can almost always be published in a jurisdiction that's not subject to a US court's reach. Second, trying to keep various websites and social media users from disseminating information is like playing a game of whack-a-mole, right? Even if you squelch it in one place, it's going to pop up in another. And for a court to issue an injunction, it has to find that it would be effective to protect the interest at issue, the national safety and security interest, which is never going to be the case once the cat is out of the bag. And that brings us to some of the latest cases involving a prior restraint on the publication of information that government entities deem dangerous to national security and safety, the 3D gun printing cases. 3D printed guns are guns made using a 3D printer, which these days can cost as little as $200. The printer uses CAD files, blueprints that are created on a computer and that can be emailed or downloaded online. The company at the center of the 3D gun printing cases, Defense Distributed, debuted its first 3D printed handgun called the Liberator, shown here, in 2013. The Liberator is made primarily of ABS plastic, the same material used in Lego blocks, but it can fire standard metal handgun rounds. Defense Distributed's printing plans for the Liberator require a metal firing pin, and in order to comply with federal law, a piece of embedded steel whose sole purpose is to trigger metal detectors. But if you were to print the gun without the steel piece included, which is definitely possible, and if you were to remove the firing pin and put it in your pocket, say, you could probably put a Liberator in your carry-on luggage and get through airport security with it undetected. Moreover, 3D printed guns don't have serial numbers, making them what are called ghost guns. It is not illegal under federal law to create or possess a ghost gun, but because they don't have serial numbers, tracing ghost guns that are used to commit crimes is much harder than tracing serialized weapons. There are no manufacturer or sales records to check, and it's a lot easier to destroy metal and plastic than metal if you want to get rid of the evidence. Further, people don't have to go through a background check to get a 3D printed gun, as they might if they bought a commercially produced firearm. Cody Wilson, who founded Defense Distributed, was a 2L at the University of Texas Law School when he learned about 3D printers. Inspired by Julian Assange and WikiLeaks, he decided to create an open source platform from which users could download the blueprints for printing 3D guns for free. He has said that he was motivated by his belief that the state should be as weak as possible relative to the individual, and that the proper posture of the state is one that is in fear of its citizen, not one that lords it over its citizens. Like a lot of the defendants in First Amendment cases, it is easier to defend the principle than the person. Soon after Defense Distributed debuted the Liberator plastic gun, the State Department moved for and obtained an injunction barring the distribution of Defense Distributed's 3D gun printing blueprints. I'll give you just a little bit of background on why the State Department was the government entity that sued. The State Department is charged with regulating both the export of firearms and the export of non-public information about firearms. In the State Department's view, because the internet is global and Defense Distributed's gun printing plans were available to virtually anyone, anywhere, via the World Wide Web, putting the blueprints online was akin to exporting information about firearms to people in Russia, China, and the rest of the world. Because the plans were not public until Wilson put them on the internet, Defense Distributed, by posting them, had violated the law prohibiting the export of non-public information about firearms without first getting a license from the State Department. The State Department refused to grant Defense Distributed such a license because the Obama administration said it would endanger our national security to have the plans publicly available. Now, refusing to allow a publisher to publish information without first obtaining a license from the executive branch is, of course, squarely and precisely what the prior restraint doctrine forbids. Wilson took down the plans, but then he sued the State Department in 2015, requesting a preliminary injunction that would allow him to repost the plans. He argued that under the First Amendment, he had a constitutional right to distribute the gun blueprints, which he said were protected speech, unlike the guns themselves. It's software, he said, but the software isn't any different from a printed manual or a book containing gun-making instructions, which would undoubtedly count as speech covered by the First Amendment. Two lower courts ruled against him. But then this past June, the State Department suddenly gave up. The reasons are complicated, but they have to do with the fact that jurisdiction over small arms export was to be shifted from the State Department to the Commerce Department, and the Commerce Department had decided that it was not going to object to publication of Defense Distributed's designs. So the State Department settled with Defense Distributed, reimbursing the company its nearly $40,000 in legal fees and allowing it to post the plans online again. A State Department spokesman conceded publicly that it would likely have lost the case on prior restraint grounds. Under the settlement, Defense Distributed was able to post the 3D blueprints online on August 1st, 2018. But that same day, Washington State and several other states filed suit against the State Department and Defense Distributed in the U.S. District Court for the Western District of Washington State. They sought an injunction that would block the release of the blueprints. Their complaint alleges that the public availability of the gun plans poses a serious threat to the national security and safety of citizens. It points out that 3D printed guns are often unrecognizable by standard metal detectors because they're made out of materials other than metal, and that they're often untraceable because they contain no serial numbers. Anyone with access to Defense Distributed's CAD files and a commercially available 3D printer could readily manufacture, possess, or sell such a weapon. Even people statutorily ineligible to possess firearms, including violent felons, the mentally ill, and those subject to protection or no contact orders. The states claim that in allowing Defense Distributed to repost its designs, the State Department effectively removed gun printing plans from the list of export controlled items without giving the 30-day notice required by the Administrative Procedure Act. I'm not an APA expert, but I'm told that the problem with that argument is that the State Department did not actually remove 3D gun printing plans from the export control list. What it did was approve the public release of the Defense Distributed plans, thereby effectively granting a license to Defense Distributed to publish the plans. And so because nothing was actually removed from the export control list, the APA did not require any notice. Nonetheless, Robert Lasnik, the federal judge hearing the state's case, sided with the plaintiff states, which now number 19, including Minnesota, plus the District of Columbia. Judge Lasnik temporarily blocked the settlement between the State Department and Defense Distributed and reinstituted the State Department's ban on Defense Distributed's posting of the plans. However, by the time Judge Lasnik issued the TRO, Defense Distributed had already reposted the designs and more than 1,000 people had downloaded them. They've been taken down again, but in the meantime, there are thousands of copies of them floating around the internet. Judge Lasnik found that the states had shown that they would be irreparably harmed should the designs be posted online. While the export laws deal with international transactions, allowing the plans to be posted online means that anyone, not only abroad, but domestically, could download the plans. And that could promote the proliferation of plastic guns, which could affect state governments as they try to enforce their gun control laws. Nor was he persuaded by the fact that possessing a fully plastic gun is already illegal. It is of small comfort, he said, to know that once an undetectable gun has been used to kill a citizen of one of the plaintiff states, the federal government can seek to prosecute a weapons charge in federal court while the state pursues a murder conviction in state court. While Judge Lasnik found that the APA claim had merit and did not rule explicitly on the competing First Amendment claims, he did hold the following. He said, the court finds that the irreparable burdens on the private defendant's First Amendment rights are dwarfed by the irreparable harms the states could suffer if the existing restrictions are withdrawn, and that overall, the public interest strongly supports maintaining the status quo pending this litigation. Again, this is the issue that the trial court faced in the Progressive case. Issuing the injunction would infringe First Amendment rights, but refusing to issue the injunction could result in multiple preventable deaths and serious injuries. Meantime, Defense Distributed has filed another lawsuit against the state of New Jersey, which sent a takedown notice to a website that hosted Defense Distributed's gun files. Hosting such gun files violated a New Jersey statute. Again, a takedown notice is a prior restraint. These three gun printing cases mean that, once again, the courts have to decide whether the narrow exception that Neer versus Minnesota described for publications that pose a threat to national safety and security does allow the judiciary to issue an injunction that acts as a prior restraint on speech. We'll have to see whether these cases make it up to the US Supreme Court case. It seems doubtful to me, though, that 3D gun printing instructions pose the kind of dire national security threat that could justify the issuance of such a presumptively unconstitutional prior restraint. That is especially so when the speech in question is not only already in the public domain, but on the internet. And given the nature of the internet and social media, once the speech is out there, there's no putting the cat back into the bag. Thank you. Yeah. Right. Right. Yeah, so there, again, there isn't any necessity to decide whether those speakers would count as members of the press, because the way that the court has interpreted the prior restraints doctrine is by viewing it as grounded squarely in the free speech clause. So we're really talking about First Amendment rights that extend to everybody, including corporations and non-citizens. But and again, those kinds of injunctions against speech do constitute prior restraints. Prior restraints are allowed in a very limited number of circumstances. They are generally not allowed in defamation cases. They have not historically been allowed in privacy cases. Generally, the remedy in those cases is to either sue, on a statutory basis to prosecute somebody criminally, or to go after them civilly in a tort suit for defamation or invasion of privacy. And if the elements of those torts are proved, then it would be possible to get relief at that point. But to bar somebody in the future from posting particular speech should come under the presumptive unconstitutionality doctrine of prior restraints.
So, is there some kind of control
Well, I'm sorry. Oh, I'm sorry. So the question was whether there's some tipping point at which the threat to national security or safety is sufficient to pose the kind of threat that's an issue. And I would say that certainly it's part of the reason that the number of plaintiffs in the defense distributed case has grown to 19 states, right? So even if one gun in one place isn't going to do it, or 1,000 guns, if you have multiple states saying that people in all these places could be printing these guns, then the numbers, the potential number of casualties starts to rise. Well, I have not seen it. So, but yeah, I don't think that we have yet seen an instance in which the publication of information poses such a dire threat to national security and safety as to justify its injunction. And it's hard to imagine that modernly there could be such a case, no matter how grave the threat, even if we're talking about the threat of thermonuclear annihilation, because of the ineffectiveness of the injunction. So I think this is going to be an exception that slowly dies a quiet death. Yeah. Yeah, in those cases, I mean, where the injunction is narrowly tailored to specific information or images that have already been deemed constitute harassment, then it's not a prior restraint, even though it applies to future speech because the speech at issue has already been adjudicated.
Do you have a feel for health prevalence? Are you prior to year?
Yes, I mean we had all kinds of licensing requirements, right? Movies had to be licensed before they could be publicly released. Books had to be evaluated to determine whether they were obscene without any kind of governing standards for what counted as obscenity. So yeah, they were quite prevalent throughout the United States.
once in the webinar.
Yeah.
The question is, on what basis can a reporter now protect his or her sources?
So there is no federal law that confers a reporter's privilege on anyone. There is no, although there have been a number of attempts to get one through Congress, it hasn't happened. And in Brandsburg, the Supreme Court didn't recognize a substantive reporter's privilege under the First Amendment. So the only protection for reporters to protect their sources and information comes through state statutes, state common law, and federal statute. That sounds more dire than it is because every state, I think with the exception of maybe one has, or two, has a statute or common law that protects reporter's privilege against compelled disclosure in particular cases, but because it's on a state-by-state basis, they vary incredibly, and it is difficult for publishers of national publications not to have to sort of pander to the lowest common denominator of their publishing nationwide. Great, thank you.